Hello all, welcome. Today we will be covering the federal preemption of state law asbestos claims in the railroad industry. As part of this video, we will cover the audio recording of the case and also cover the decision by the court at the end. The case centers on the estate of George Corson, a longtime railroad welder and machinist who was diagnosed with mesothelioma, a deadly cancer linked to asbestos exposure. During his career, Mr. Corson worked extensively with locomotive brake shoes and engine insulation, both of which contained asbestos. His family filed a lawsuit against the manufacturers of these parts, alleging that the products were defectively designed and that the companies had failed to provide adequate warnings about the life-threatening risks associated with breathing in asbestos dust. The legal battle moved to the federal level when the manufacturers argued that the lawsuit could not proceed in state court. They claimed that the federal Locomotive Inspection Act, which dates back over a century, gives the federal government exclusive authority over the design, construction, and material of locomotives. According to the companies, this federal oversight completely blocks or preempts any state law claims that attempt to regulate locomotive parts through personal injury lawsuits. The legal question presented is whether the federal act is so broad that it stops injured workers from seeking damages under state law for design defects and a failure to warn. Following is the audio recording of the actual court hearing.
We'll hear argument next this morning in Case 10-879, Kurns versus Railroad Friction Products Corporation. Mr. Frederick.
Thank you, Mr. Chief Justice, and may it please the Court. Congress enacted the Locomotive Inspection Act to ensure the safety of locomotives in use on railroad lines, not to regulate hazards to mechanics conducting repairs of locomotives. The doctrine of implied—
What do you make of the ICC in 1916, in the Tiller case, regulating the lights that railroads had to have, locomotives had to have in the yard, and that those lights had to differ when the railroad was in use?
That was actually, I think, pursuant to the Safety Appliance Act, Justice Sotomayor, if I'm not mistaken. And the principle behind the safety in use regulation that this Court construed in Napier was to ensure that locomotives were safe for fit use on the line. And that was the consistent construction both in the ICC's statement that it made in 1922 and in this Court's post-Napier—
I'm not sure I understand. It prescribed different lights when the locomotive was in the yard.
Yes.
It had nothing to do with safety in use. It had to do with safety in repair.
Our position is that it was not pursuant to the Locomotive Inspection Act that the ICC promulgated that rule. As the Court has said in numerous cases, the ICC had rules in place with respect to different aspects of the train at different points in time. But the Locomotive Inspection Act was designed to address a very specific problem, which was boilers exploding on the line when the train was in operation. And that is the consistent way that the ICC and subsequently the Federal Railroad Administration—
Distinguish for me our reasoning in the Ray case.
I'm sorry?
Distinguish for me the reasoning in the Ray case that had to do with navigation, and where we held that the agency, in ensuring safety and navigation, controlled design completely, whether in repair or not. So why don't we apply the logic of Ray to this case?
Well, of course, in Ray, you address the Port and Taker Safety Act as well as the Port and Waterways Safety Act. And in the United States versus Locke case, the Court subsequently looked at Ray in terms of design in a statute that also specifically included the word repair and maintenance, which is absent here. But what the Court was getting at in Ray was to ensure that states were not using their law to interfere with the design of equipment. Of course, that was for—
That's the argument here, which is once you regulate what the design or use of asbestos is, you're interfering with what available components there are for locomotives.
If I could make 2 points about that, Justice Sotomayor, that's not actually correct. The first is anything that the Court might think about design does not impair our failure to warn claims, which entail no challenge to the design of the locomotive at all, only to the instructions for its safe use. But to the
So you're giving up all of your other claims?
My second argument is that the design claim here involves repair worker problems uniquely. It does not include or intrude on the fitness for service standard that this Court announced in Napier or that has consistently been applied. The asbestos harms that the repair workers here faced are unique to the repair process, where they are scraping.
Well, but counsel, I'm looking at Napier. The power that the Justice Brandeis said was conferred in that case was to specify the sort of equipment to be used on locomotives, right?
Yes. But
so this is equipment that was used in locomotives.
Yes, but, Mr. Chief Justice, it also says on page 612 that the power delegated by Congress is to determine fitness for service. So the words about
that's the same thing. I'll give you that, fitness for service.
No,
it doesn't say something that's going to cause harm while it's actually being used.
But, Mr. Chief Justice, the principle here is to ensure that the locomotives, when they are outside the repair yard and are on the railroad line, are safe to operate. That standard, and Napier had no occasion.
Why does it depend? You want to know if this equipment is safe to operate, right? To be used, whether it's going to be used.
Not to be broken down.
If you have a boiler that's going to be used, that's within the power that was confirmed. It's not merely to inspect, as, again, Justice Brandeis said.
But the point here is that it is not to be broken down, and the locomotive repair workers here face unique hazards in repairing locomotives whose safety standards are to ensure that they work properly on the railroad line, not when they're being taken apart and repaired.
Well, I guess your argument isn't limited to being taken apart. Your argument does depend on the fact that the asbestos doesn't come out during use, right?
That's absolutely correct. That's why this is a unique hazard faced by the repair workers.
Yeah, but if there's an accident or something, does the asbestos come out during the use of the locomotive?
If it did, it would be covered under the Locomotive Inspection Act safety standard, and that would be covered.
You would say once there's an accident and the locomotive is disabled, it's no longer in use. I suppose that's what you'd say.
That's correct.
It's unrealistic, but that's what you'd say.
No, well, it's governed by a different statute, which is found at 49 U.S.C. 2.
Well, that's the old insurance, the cases we've had, that, when the car, slams into a pole or something, it's not being used as a car anymore, and therefore the insurance doesn't cover it.
Well, if I could finish my answer to your previous question, Mr. Chief Justice, there's a specific statute on that point, and it predated the Locomotive Inspection Act, and it provided that when there was a crippled locomotive, the railroad did not face liability civil penalties to bring the crippled locomotive back to the yard, but it specifically said if a worker was injured during that process, the railroad could face liability. Our point here is that the Locomotive Inspection Act's field should be construed narrowly because in 1970 Congress expressly and comprehensively legislated in the Federal Rail Safety Act and provided a conflict preemption regime in which if a state had a rule in place, that rule would be permitted to survive unless and until the Federal Rail Administration issued a regulation, and there has never been a regulation on asbestos.
What I'm concerned about, I think, is the same thing that Chief Justice mentioned, the particular language in Napier. And however this might come out today if Napier were decided again, it did come out the way it did. And Justice Brandeis did write it, and it's been the law a long time. And the argument is made in Napier that this particular state regulation is aimed at preventing sickness and disease, not at making locomotives safe. And therefore, it's not preemptive. And the answer to that was not sickness and disease are an object of the statute too. The answer was the federal and the state statutes are directed to the same subject, the equipment of locomotives, and therefore it is preempted. Now, how could we come out in your favor without overturning what seems to be that key sentence in Napier? That is the problem that's bothering me.
Well, first I would urge you not to read Napier like a statute, although Justice Brandeis is obviously...
Okay, that's A. The problem with A is that it's been followed and followed and followed and followed and really read for all it's worth and so forth. So one question is, to what extent can I go back and revise that sentence. That's A. Okay. What's B?
B is that he was addressing himself to fitness for service standards on the line, the Wisconsin and Georgia statutes at issue there, purporting to regulate what the locomotive could do while it was in operation on the line. That's not what the claims.
Not now. Is there any way that you could win your case in reasonable way, not some far out way, but you win your case on this, and it does not affect the manufacturer's way of dealing with their equipment?
Yes.
What is that?
First is if you accept our proposition that warning claims are valid negligence claims, the warning claims do not affect the equipment, how it is made at all. It's simply how do you use the equipment safely. Secondly, the design claims here go to the unique hazards faced by repair workers. You could use asbestos under our theory of the case on the locomotive in exactly the same way that the locomotive equipment manufacturers have done, so long as there's a safer way to take the asbestos off the locomotive in the repair yard. That is a distinct kind of design claim that doesn't go to the safe operation of the locomotive. It goes to what hazards are created when a repair worker is doing maintenance work.
I'm not sure I understand this. Are you talking about wearing a particular hazard suit? Are you talking about blowing out air, or are you talking about changing the design so that the asbestos comes off without the dust cloud that's generally created?
Both. The dust cloud is something that can be warned against and protected against with protective gear that has nothing to do with the design of the locomotive. There are, and there is evidence that there are safer and were safer ways to remind you that asbestos isn't used on locomotives anymore, so this is part of an historical debate here. But in ways that could be removed that would not create the cloud dust. That's the essence of the design defect claim. And the LIA and the FRA do not regulate in the repair shop. So there's a
gap. I'm sure I understand you. Is if the Secretary tomorrow decided to issue a regulation saying railroads should no longer use these asbestos-containing brakes because of the hazards in the repair shop, do you think the Secretary could not do that under the statute?
No, absolutely can do that under the Federal Rail Safety Act, which empowers the Secretary.
But the Secretary can't do that under LIA? Is that the idea?
It very well could, because it's a fitness for service standard. But it always, and if you look at its regulations in Parts 229 and Part 230 of 49 CFR, it always issues these regulations under both authorities because the FRSA
Okay, then I'm a little bit lost. If the Secretary can issue such a regulation under LIA, then isn't it in the scope of regulation, and then isn't it also in the scope of what's preempted?
It would have to do so under the B&O Railroad case in the early 1930s. It was another Justice Brandeis opinion in which it would have to make a finding that to make that regulation that you posit, Justice Kagan, was necessary to avoid unnecessary peril to life or limb. In that case, the Court struck down the ICC's attempt to issue a regulation on a particular type of equipment because the ICC could not make that demonstration. So in the current world, the FRA would regulate under the FRSA. It would not regulate under the LIA because under this Court's jurisprudence, it is a harder standard to meet to implement a regulatory standard. That's our point. The regulatory field here does not need to be read as expansively as the other side posits because the FRA has all the authority it needs under the FRSA if it chooses to promulgate those rules, and it has not chosen to promulgate those rules. The FRA can use conflict preemption to displace any state rule. But what they are seeking to do is to take the doctrine of implied field preemption, gain immunity from state law liability, and not be subject to any federal rules. And it's that proposition that is an extraordinary proposition of implied field preemption. We found no case from this Court that goes that far.
Could you clarify what is at stake for the worker here? Now, the railroad worker ordinarily has the FELA claim, but the FELA claim in this case was dismissed. So can you tell us what recourse, if you lose, what recovery can this plaintiff get? And also explain to me why the FELA claim was dismissed.
If we lose this case, Justice Ginsburg, the decedent's family gets nothing, takes nothing, because the FELA claim was rendered summary judgment on the finding that there was no negligence by the railroad. The only claim that the decedent's family has here is a third-party claim against the manufacturer for failing to warn or design defect on the basis of state law.
You just said that, which I think you certainly have the right to bring a claim, don't you, to say the repair shop doesn't have adequate warnings. And if that's the railroad's at fault in that, or the manufacturers, or the owner of the repair shop, everybody, whoever puts the asbestos in there is negligent and not putting up adequate warnings. What's wrong with that?
Well, here, ordinarily you'd bring a failure to warn claim directly against the manufacturer for not putting in the manual or stamping on the.
But what about getting away from the equipment and saying the failure here is not to fail to put it on the equipment, it's to fail to put it in the repair shop?
It's
something
both.
I'm not seeing.
No, it's both. Manufacturers routinely are held liable for failing to warn if in their manuals or in their other instruction materials they do not provide for instructions for the safe use of their equipment. If I could save the balance of my time.
Thank you, Mr. Frederick. Ms. Harrington?
Mr. Chief Justice, and may it please the Court, I think it's helpful in this case to try to separate out the field preemption issues from the conflict preemption issues. In the government's view, the only issue properly presented in this case is whether petitioners' tort claims fall within the field preempted by the LAA. And our view is that they do not, because they arise from injuries that occurred when the locomotive was not in use. Now, a respondent would have the Court expand the field that's preempted by the LAA to include any claim that has anything to do with locomotive equipment, regardless of whether the equipment or the locomotive was in use at the time an injury occurred. But it doesn't make sense to
Don't you think that one of the purposes of the legislation, which everybody understood, was to enable engine manufacturers to be able to construct their engines without having to worry about a variety of different state requirements? Railroading is a national transportation industry, and whoever makes the engine has to know, if I do it this way, it's going to be okay.
Absolutely.
And you're saying it won't be okay because although every state may have every state's requirements may be preempted when the locomotive is in use, all 50 states can have different requirements with respect to what the design has to be in order to make the engine safe when it's being repaired. I think that truly frustrates the purpose of the Act.
I completely agree with what you're saying, and I'm sorry if we didn't state our position clearly in our brief. Our view is that those kinds of requirements that go to the design, construction, or materials on a locomotive that will be used, if those requirements are directed at the repair shop, then they would be conflict preempted. But they wouldn't fall within the field that's governed by the LIA because the LIA's substantive standard of care only applies to locomotives that are in use.
So it would —
I'm not concerned about conflict preemption. I'm not concerned about state requirements that conflict with the federal. I'm talking about 50 state requirements that conflict with each other, so that the manufacturer has to look to all 50 states instead of looking to the secretary here, which says your engine is safe if you do this. And you're telling me the manufacturer can no longer assume that.
No, I'm sorry, and let me clarify. I appreciate the opportunity to clarify. In our view, what the conflict is not a conflict with a federal rule saying you have to use this piece of equipment and you can't use that piece of equipment. The conflict is with one of the purposes of the LIA, which is that the federal government be the only regulator of equipment that will be used on a locomotive. And so what that means is if if the federal government hasn't spoken to whether a piece of equipment A can be used on a locomotive, that means it can be, that the manufacturers know that it's okay. And if you have a state rule that would have the effect of dictating the equipment that can be used on a locomotive, that would conflict with the single regulator objective of the LEA.
What's the difference then? How do you do it? How do you, what is it you're thinking of that the manufacturer is going to have to do in respect to his locomotive in order to comply with the state law about warning that he's not going to mean that he changes the locomotive when it runs on the railroad?
Well, I think it depends on what the warning claim is.
Give me an example.
Well, under the respondent's view of the field that's preempted, a state could not regulate the disposal of equipment that's removed from a locomotive during the repair process.
Does that have anything to do with this case, the removal, no further use of a bit of a locomotive?
No, but also...
No. Okay, let's get to this case.
Also in respondent's view, a state could not regulate workplace hazards, such as by requiring that workers wear goggles or masks.
Oh, I didn't know anybody denied that the state could regulate the repair shop, indeed require what warnings they wish, indeed require what equipment the workers have to have. I thought we're only talking about those rules of state law that would affect what the manufacturer has to put by way of design in his locomotive.
Yes, but
that's what I'm having trouble of thinking, one that would only affect repair shops and repairs, but maybe there's some kind of equipment that you could stick on the front of it and it is a hook or something and it holds something, and before it goes back on the line, you take it off and put it in a locker. And but you know, the more I thought along those lines, I thought I'm getting into outer space. This isn't reality.
No, I think you could imagine a world where a state says when a locomotive comes into a repair shop, the railroad or the repair shop has to attach a certain kind of clamp on the wheels, a certain kind of brake that makes sure that the locomotive won't move while it's in the repair shop. And when you're done repairing the locomotive, you take them off and the locomotive goes
All right. Now, does that have more than theoretical value in this case?
Well, I think in this case, the claims that we say would not be conflict preempted or within the field are the failure to warn claims. Now, how a manufacturer actually issues the warning that would be required, I think, is a question that could be worked out as the case proceeds.
If the manufacturer is really not controlling the repair shop, of what value is this failure to warn claim?
Well, again, I think it depends how the warning is issued. You could require that the manufacturer tell the purchaser of the products to pass the warning along, to post warnings in a repair shop. You know,
they can't control whether they do or don't.
They could require it contractually through the sale of the products. I think those sorts of detailed issues would be things that would be worked out on remand in this case. Again, in our view, the only question squarely presented in this case is the field preemption question.
And so on that question, Ms. Harrington, I'm still confused about the scope of your regulatory authority and whether you think you have the capacity to issue rules that are meant to protect repair workers on railway equipment. So can you issue a rule under the LIA that says no asbestos-containing brakes because we're afraid that these brakes injure the guys in the roundhouse?
No. The LIA, the standard of care under the LIA only goes to whether a locomotive is safe for use. And that is also the limit of the FRA's regulatory authority. This Court in United States v. B&O addressed that issue. The ICC at the time had issued a regulation requiring a certain kind of reverse gear instead of a different kind of reverse gear. But
now, what's self-abnegation by the federal government that safe for use does not include safe for use when it's being repaired?
Because the statute says safe for use on the line. It's safe for use on lines of interstate commerce.
But this does seem a very limiting construction. Napier seems to have a broader construction, and if I read some of your history right, you've taken a broader understanding of your regulatory authority in the past. So why this narrow view?
I'm not aware that we've taken a broader view of our regulatory authority under the LIA. In Napier, again, what's important to remember is that the state statutes at issue applied only to locomotives that were in use. And so I think it's hard to take any broad statements that were made in Napier and read them as applying.
Well, but if you're talking about, I bet there are a lot of things on railroad cars that you can fix in the shop or you can fix while it's underway, right? We're not always talking about brakes. So let's suppose there's one of those things. You get to the shop and I said, boy, you got to fix this. And they said, well, the train's leaving, we're going to go in 10 hours. He says, okay, I can fix it while it's in use. Is that covered or not?
Well, again, the LIA only applies to the locomotives. So if the thing that's broken that you could fix while it's in use would not make the locomotive unsafe to use, then it would not be a violation of the statute to use it while the thing.
So the line you've been talking about between the repair shop and the locomotive on the tracks, that's not really the line at all.
The line is the in use versus not in use. And that tends to...
Well, then what's the answer to my question? This is something you can fix in either place. It's covered if you fix it while the train's underway, but it's not covered if you wait till it's in the shop?
Well, if the fact that it's broken makes the locomotive unsafe to use, then the railroad cannot use it, cannot repair it while it's in use.
So then it's not whether it's in use or in the shop. It's whether it is something that affects whether the locomotive can go, whether it's being used.
That's right. But here the injuries occur when the locomotive is not in use because it's in the repair shop. And in those situations, the LIA's substantive heightened duty of care doesn't even apply. And so it doesn't make sense to think of those claims as being within the field that's preempted by the LIA because they're not governed by the LIA. Now, those claims might bump up against the LIA in a different way by conflicting, again, with the
Can you have any — I'm sorry. Go.
Can you explain the difference? You make a distinction between field preemption and conflict preemption. Does that have any practical significance at all in this case? Because I thought you agreed that the design defect claim would be barred.
Well, we agree that they might be barred. I think, this case comes to the court without any real development of the plaintiff's claims. All we have is what they stated in their complaint. Their complaint incorporates a master complaint, which applies to all sorts of different kinds of plaintiffs. And so I think it's really hard to understand exactly what their claims are, what the effects of their claims would be with respect to the design defect claims. And so, in our view, the design defect claims would be preempted if they would have the effect of dictating the character of equipment that could be on a locomotive while it was in use.
Thank you, counsel.
Thank you.
Mr. Hacker?
Mr. Chief Justice, and may it please the Court. The LIA, as construed by this Court in Napier, in particular in the passage quoted by Justice Breyer, delegates to the DOT the exclusive authority to determine the design and the materials of locomotive equipment. Petitioners, however, argue that states, in fact, may dictate locomotive design and materials, so long as they do so for some purpose other than safety of use on the line. But, as again in the passage Justice Breyer pointed out, Napier holds that LIA preemption is not about the purpose of locomotive equipment regulation and is not about the geographic location of the locomotive on or off the line when the regulation is enforced. As Justice Sotomayor pointed out in the earlier argument this morning, regulatory power is broader than purpose. As Napier says, under the LIA, preemption is about the locomotive equipment itself, what Napier referred to as the physical elements of the locomotive.
Well, Mr. Hacker, could you explain to me, I wasn't sure reading your brief whether you agree or disagree with the government's point that the agency cannot, under the LIA, issue the kind of rule that I suggested, just, saying no asbestos-containing brakes because of the danger that those brakes pose to the repairmen.
Frankly, I would have thought it possible. I would have to defer to the DOT's view. It seems to me it would have been within DOT's power under the LIA to say a locomotive is not safe to operate if it can't be safely repaired, because there's no point in having a locomotive ready to go on the line if it's, as soon as it comes off the line with a problem, it's going to injure those who work with it. But we don't need to assert that position to defend the proposition we have now.
Well, how is that? If they're right as to the scope of their authority, and maybe they're not right, but if they're right about the scope of their authority, why doesn't it follow that these claims would not be field preempted, might be conflict preempted, but would not be field preempted because we're no longer in the field?
Because the field is not — it's not about the repair shop versus not the repair shop. The field is the physical elements of the locomotive itself. What states cannot do, what DOT has exclusive authority over, is the design the materials and the construction of the locomotive.
But only the design, materials, and constructions for use. If you make that concession, it's only those aspects of design, materials, and construction that pertain to use. And if you take the position that use includes only use on the line and not use when it's being repaired in the repair shop, I think you're in trouble.
I think we're not, Your Honor, because the design doesn't change between the line and the repair shop, and that's the key. If a state comes in and says
it's designed for use,
I understand.
I'm not talking about the word design. I'm talking about design for use.
But the statute, the reason the statute gives power to the DOT is to ensure that locomotives are safe for use on the line. But in order to accomplish that objective, the power they have is plenary over the design itself. Only one entity gets to decide what the design is, and that's DOT. A state can't come in and say,
it's not clear to me why a railroad executive couldn't say, now I need to use 10 locomotives in this division because I will be using 2 of them every week in the repair shop to repair them. I don't know why that isn't use, but you don't seem to agree with that.
Well, I don't necessarily disagree. We would certainly accept that proposition. We're just saying you don't have to go there.
I know it's the use on the line, but it seems to me that the repair shop is an obvious extension of the line. Everybody knows that it's going to have to spend 1 day a month in the repair shop, and that's just part of the use.
We don't disagree.
Why would there a law be preempted, a state law that says since the railroad knows that asbestos is dangerous when revealed, and since it would be revealed in a repair shop, the railroad has to provide the repair shops with appropriate worker safety equipment? Or alternatively, in lesser, the railroad has to provide for the repair shops documents to be given to the workers which explain the risks and how they can overcome them. Now, in respect to that, which I'll lump under various kinds of failure to warn claims, how does the Act preempt those? It doesn't affect design of the railroad, nor does it affect the use, neither.
I would say two points, Your Honor. First of all, it does affect the design because a way to comply with that regulation is to use something other than asbestos, to change the design. It's the state saying, because you're using this design, you can only use it lawfully in this state if you do the following two things.
I thought that was not the nature of the notice claim. The design is whatever it is, but the manufacturer has to issue warnings so that the worker can protect himself against that hazard. So I thought that the defective design, yes, I understand your argument. You would have one standard for on the line and another when it's in the repair shop. But this is not telling them to change the design in any respect. It just says asbestos. You can take these measures to protect yourself.
At common law, a failure to warn claim was a type of design defect claim. It was a way of saying you can't use that design lawfully unless you have the following type of warning. If you can't assume away the design aspect of it because it still turns on, it's the state conditioning the design. The LIA and the FRSA and the SCAA and OSHA all together solved this problem and FELA solved this problem by saying it is the repair shop's responsibility to ensure the safety of workers. We are not, to be absolutely clear, Ms. Harrington was incorrect when she said we don't believe that repair shop states have the power to impose workplace conditions to protect employee safety.
That argument would prevent states doing what they can do lawfully, which is to regulate the repair shop. Because with any given repair, with many of them, you could say, well, we wouldn't have to we could just change the locomotive design, for example. It carries beds with it so that the workers who are repairing it get adequate sleep. I mean, that isn't an answer to the argument that it doesn't affect design to say, well, they could comply with it by changing design. I don't think.
Well, what we would say is that generally applicable laws that govern the repair shop States have authority, to the extent not preempted by OSHA, states have authority to require workplace conditions and to require employers to protect employees working there. What they can't do is tell manufacturers, here's the conditions under which you can use this design, sell this design, distribute this design, and these materials lawfully within the state.
What would apply to the repair shop would also apply to the locomotive in use, I suppose, and it would be of little comfort to the manufacturer that although the engine he's manufactured has been certified as safe for use by the Secretary, he is liable unless he warns the engineer, it isn't safe for use in these circumstances. I have to give you warning. I mean, I cannot imagine that that's what the statute means as applied at least to the use of the engine on the tracks.
Well, we agree with that, but we also think it applies with respect to the manufacturer's liability in the repair shop for the reason I said earlier, that the locomotive doesn't change. So when it's certified as safe for use online, it can't be, and the locomotive manufacturer knows everything they know by looking at DOT regulations. It can't be that a state can come along and say, no, you can't use any of that design. You have to use this completely different one.
No, what they're saying
this will make it safe in the repair shop.
They're saying is because when you open up the box, something no one does online, you will expose yourself to risks. And what we are saying is, therefore, you must post a notice that tells workers about those risks. And indeed, if there is a conflict preemption will take care of it. But why should that kind of thing fall within the scope of field preemption, even under Napier, which, of course, referred to equipment, while this rule doesn't? It refers to a sign. You're not going to change the equipment.
Well, for the reason I said earlier, Your Honor, which is you don't know in advance. If you say in theory a state can adopt a warning requirement specific to a design otherwise approved by the DOT, you don't know in advance whether the warning requirements, manufacturers will be able to easily comply with all 50 different types of warning requirements, and whether or not the warning requirements, some will be so stringent that it would be easier to simply adopt a different design. The point of the LIA is to take that kind of decision-making out of the state's hands and put it into a federal authority which can make the relevant and appropriate decisions with respect to what designs are lawful.
Suppose the allegation is that there's a failure to warn workers to use a special kind of mask that's very important if you're working near asbestos. That's the claim they want. Now, are you saying that the manufacturer cannot be required to give that warning?
That's correct.
Are you also saying the railroad cannot be forced to give that warning in its repair shop?
The railroad can be required to ensure the safe protection of employees that work there. A workplace safety claim is really a warning claim.
Can the railroad be held liable for failing to tell the worker to use the mask?
It can be under OSHA. Be held liable for that.
And can the manufacturer be held liable for failing to tell the railroad?
No. That would be a failure to.
How is the railroad going to know whether it's unsafe or not?
Because
how is the railroad going to know whether there's asbestos in there unless the manufacturer at least tells the railroad, even if it doesn't have to tell the worker?
Railroads have a duty under FELA to ensure a safe workplace environment. That's clear. And so they have adequate incentives to ensure that their employees have a safe work environment. If a worker is exposed to asbestos.
But you said could state law say you need a special kind of mask?
Well, not under the current regime, because FELA would preempt any claim by a railroad worker. So there isn't room for state law.
What about
already.
An independent contractor who's not covered by FELA?
Could not have a claim against the manufacturer. An independent contractor would not have a claim against the manufacturer.
Under a state law which, by hypothesis, says you need this very special kind of mask. It's required only in Illinois.
Right. The manufacturer could not be held liable under that state law. That would be a condition on the design, an effort by the state to prescribe the condition, the type of design that
could
can be
lawful. Could the railroad be held liable for failure to give that kind of mask under state law if it's not a FELA worker?
If it's a generally applicable law about asbestos use, yes. I would say at some point a law like that's directed at a particular type of equipment becomes potentially conflict preempted because it puts a condition on the design of the particular equipment. States are free to enforce generally applicable laws about safe workplace environments, asbestos handling.
Let me ask this question. Is it your position that the engine is as much in use when it's in the shop as when it's running on the track. Is that your position?
We don't have a problem with that position. Because we don't believe you have to establish that it's in use in the repair shop to establish that the preemption described by Justice Brandeis and Napier controls, because the preemption he was describing was the regulatory authority was over the equipment itself, which is the same exact equipment. A locomotive designed a particular way doesn't change when it enters the repair shop. So it's designed to be.
Well, the reason it seems to me somewhat important is that I can't conceive of 50 different state regulations for the kind of gloves and things that the engineer has to wear on when he's running the train on the track. And if that's so, it seems to me it would help you to say that the shop is the same, but you seem to say the shop is different.
Well, I only mean to say that our position doesn't change whether or not the shop is different, because it's not — the LIA preemption, LIA regulation isn't about repairing. The DOT may well have authority, they seem to think not, over repairs under the LIA, but what the LIA is about is the design and the materials themselves. And states can't say for themselves what a better or more preferable or a locomotive design is for any other reason. The Respondent's brief and reply brief on page 5 makes an interesting point. They think they've proved their case when they say the LIA doesn't, for example, permit the DOT to impose a U.S. steel requirement, a domestic content requirement on locomotives. The implication would be, of course, that a state could, because it's outside the field as petitioners define it, that a state could say locomotives can only be used within our state if they're made of U.S. steel. I don't think that makes any sense at all. It can't possibly be right, and the reason it's not right is that it misunderstands preemption under the LIA as described by Napier. Of course it's within the general authority of the DOT to determine that a locomotive should be made with U.S. steel, but that authority can be abused. It might be arbitrary and capricious. It's not permissible for them to do that. But the content of locomotives is exclusively within the jurisdiction of the DOT, and states can't decide for themselves that a locomotive otherwise compliant under federal regulations.
Well, they're not saying here you have to manufacture it a certain way. They're just saying if you manufacture it in a manner that we consider unsafe, you have to warn people.
Well, that's part of their argument, but their main claim is the first one, which is that you are prohibited in this state from using asbestos. It can't happen, even though the federal regulation said you could. That's the main part of their claim. They have a secondary claim, which is failure to warn, and which we submit is essentially a type of design defect claim that says if you're going to use asbestos, then you have to warn. And we don't even know, as Ms. Harrington was describing, there would be a lot to be determined if conflict preemption applies to failure to warn in a given case. That's the whole problem, Your Honors, is that the LIA was saying we don't want to expose manufacturers to the potential of future state court litigation.
Well, do we have to reach the failure to warn problem in this case?
I think it's presented here. I mean, we think it's completely caught up in the design defect issue. But the other side is trying to defend by saying we have a design defect claim, but we also have a failure to warn claim. But we submit the two are bound up together.
If I'm understanding your argument correctly, you're saying that if Napier controls the design of a locomotive part, that includes any design defect that's encompassed by state law, whether it's design in its traditional sense or failure to warn.
That's correct.
That's basically what the court below said.
That's correct. And that's what Judge Kaczynski said in the law case and Judge Winter said in
just as a practical matter, I'm assuming that some railroad repair yards are owned by the railroad itself, so the railroad repair people are railroad employees, correct?
I think that's right, yes.
Are there some that are not?
Well,
they're not considered railroad employees, but they're considered something else?
I don't. The two things I would say is I don't know the answer for sure, but I think there probably are. But there are also repair shops that are owned by other railroads, and that's part of a problem that manufacturers have. Is you don't know when you sell the locomotive to a railroad who is going to be repairing it under what conditions.
Just to be clear, under your view of the LIA, there could be other laws that preempt it or prohibit it. States can tell railroad yards, put signs up, wear protective equipment, do whatever it is to protect the worker from this repair. They just can't tell them
Yes.
to include a warning on the brake or to
specific to the equipment itself. What we would say is the state has to take the locomotive equipment as a given. It is what it is. And then if that locomotive equipment creates risks for workers, the employer may have to do things to account for those risks. But the equipment can't be regulated by the state. The equipment itself can't be regulated by the state in any respect.
Mr. Hacker, do you think we would decide Napier the same way if it came to us today?
I do think so, Your Honor. Of course, I don't think that matters because Napier is what it is and has been relied upon for 85 years. But I think there would be a very good argument that it would be decided the same way today under the Ray case that Justice Sotomayor mentioned. It was a very similar kind of delegation of regulatory authority, and the Court held that there was the same kind of field preemption. There are some differences one could discuss, but Napier is what it is, as I say. If the Court has no further questions, I'll cede the balance of my time.
Thank you, counsel. Mr. Frederick, you have 4 minutes.
Manufacturers clearly have the best information about the dangerous aspects of their products, and they issue warnings and instructions in manuals and provide all kinds of information so that persons working on their equipment are going to know the special hazards. It doesn't make sense to inoculate those manufacturers from liability where they have the best information to ensure that repair workers are not going to be exposed to risks. With respect to the point about being on the line, the whole idea behind the Locomotive Inspection Act was not just for use, Justice Kennedy, but also safe to operate on the railroad line. Under the regulations, and this is well established, yard limits are drawn outside the bowl where switching operations and repair operations occur so that everybody knows where the federal LIA standard applies and where it doesn't. And the reason why the LIA has had this kind of history with respect to repair work goes to the history of behind this Court's recognition of the commerce power. Up until the New Deal era, it was well settled that Congress could not legislate on intrastate activities, which are peculiar to repair yards. And so this Court, when it decided the Shanks case in the mid-1910s, held that a railroad worker could not bring an FELA claim because his work was not in interstate commerce, it was only in intrastate commerce. And that is why the ICC throughout this entire period never devoted regulations to repair yards, because this Court's Commerce Clause jurisprudence precluded federal regulatory activity for that. So if you look at this case from an historical perspective, Justice Kagan, it's not clear that the full parameters of the way the Court would explain Napier would be the same, because its approach to field preemption is so different after the New Deal era than it was before the New Deal era. And that is also why, when this Court looks at regulatory implications of common law claims, it has had no problem allowing state law to have design defect claims with respect to planes, cars, motorboats, and trucks, even though the implications of a state law claim might find liability for the insufficiency of the design and posing an unreasonable risk to the person who is exposed to that risk with respect to that interstate modality. There's no reason why you have to have a broad and expansive view of the field here, because Congress subsequently has enacted in this very area to give the federal agency preemptive authority when it deems that authority appropriate. And as the federal government says here,
it knows about Napier and what's been going on for 85 years, and if it wants to pull back on the preemptive effect of the provisions interpreted in Napier, it's free to do that too.
It did so, though, Your Honor, in 49 U.S.C. 20106, where it said that unless and until the federal government issues a regulation in a particular field, the states are allowed to have their
that
rule
was
be in effect.
The Safety Act, and they didn't amend the Locomotive Act. The Locomotive Act is what it was, and they didn't put that clause in the.
But that's why, Justice Ginsburg, the point here is how broadly do you define the scope of the field? And Napier defined it in an historical context that we just don't live in anymore. And there's no reason to give manufacturers a complete pass from liability when they have the best information to advise railroads and railroad workers how to work on their equipment in a safe way without exposing their workers to unnecessary risks. Thank you.
Thank you, counsel. The case is submitted.
That concludes the audio recording of the court proceedings. In a 6-3 decision, the Supreme Court ruled that the Locomotive Inspection Act preempts state law tort claims involving locomotive equipment. Justice Clarence Thomas, writing for the majority, emphasized the need for national uniformity in railroad regulation. The court looked back to its own 1926 ruling in Napier, which established that Congress intended the federal government to occupy the entire field of locomotive safety. The majority concluded that because the lawsuit's claims for defective design and failure to warn were fundamentally about how locomotive parts were made and labeled, they fell squarely within that protected federal field. Consequently, the family's state law claims were dismissed, as allowing such suits would create a patchwork of conflicting regulations across different states. Justice Kagan filed a concurring opinion, noting that while she felt bound by the Napier precedent, she found the results somewhat outdated given how modern law usually handles the relationship between federal regulations and state lawsuits. Justice Sotomayor, joined by Justices Ginsburg and Breyer, filed an opinion concurring in part and dissenting in part. While they agreed that the design defect claims were preempted, they argued strongly that the failure to warn claims should have been allowed to move forward. Sotomayor contended that a warning is an instruction to a person, not a piece of locomotive equipment, and therefore does not interfere with the federal government's ability to set uniform standards for how trains are built. This concludes this presentation. If you have thoughts on this case and judgment, do comment below the video. Also, to receive notifications of future cases, be sure to subscribe to the channel. Please share the channel link with your friends and peers that you think may be interested or benefit from it. Thank you.